get started with the hot topics. And hot topics, we do think about this. What are the things we want to cover? And we try to look at trends we at the Court of Appeals are seeing that are bubbling up. And we picked two for this year: standards of review and sealing and expungement. Now, standards of review may not sound that sensational. And the Supreme Court has come out with some cases to help us, especially with abuse of discretion, but you would not believe the debates that go on in the Court of Appeals on standards of review. So our first topic is going to be led by Alan Regis, and I see a lot of familiar faces, so I'm sure a lot of you already know Alan Regis. He started his career at the 8th District, was an assistant county prosecutor in Lorain and Cuyahoga County for a couple decades, including a supervisor of the appellate unit. And then I persuaded him to come back and to the 8th and work with me. So I know the debates we've had in his topics. He's going to lead us off with standards of review. Yeah.
First, I'm going to apologize to everyone that you have to listen to my voice today. I'm not apologizing for the timbre and nasalness and annoying quality to my voice. I just was at the game last night. I, as a grown man, was standing there in 4 inches of snow, screaming and barking, watching other gentlemen make snow angels. I was here 20 minutes after. Just to yell at those people with idiotic talents. Anyway. I now have a cold with this sprained vocal cord, but no, I didn't paint myself either. Okay, where am I? This button. Thanks. Can you guys read this? Because I can't over there. I guess over there. Get glasses. In the past few years, the Supreme Court has redefined how a lower court can be found to abuse its discretion and merged appellate review of civil criminal claims that a judgment is against the manifest way of the evidence. That was the reason that we're up here to talk, but I'm going to highlight those changes. But before I do that, I have to review appellate standards to a bit, from de novo to abuse of discretion to manifest way a little bit, and I'll talk a little bit about what's in between. So I think one of our earlier speakers noted that the standard of review should be part of every appellate brief and argument. Probably all you're going to get for advocacy out of me on this, other than stuff to think about. But one thing to think about, some district courts, including the one next door, up there, no, there you go back. Appellate Rule 16A7 in the 9th District, for example, says each assignment of error shall be separately discussed. That's in Appellate Rule 16. But it shall include the standard or standards of review applicable to that assignment of error under a separate heading placed before the discussion of the issue. I think every judge over here would appreciate that in embracing the 8th District too. Especially if you guys are disagreeing about what standard of review is being done. So, talking about standards of review, let's talk about the definition. There it is, definition. Anyone? Okay. Generally, these judges interrupt me. And they're being very nice to me today. So, what's standard of review? So, like any good appellate lawyer, what did I do to prepare for this? I tried to find a definition. I went to the Ohio Revised Code, my favorite place to find anything in the law, because that tells us what we have to do. It wasn't there. There's no definition of a standard of review. They say to use some standards of review. No one ever defines it. I went to the Ohio Constitution. We seem to amend it every couple of years. Maybe it's there. It tells us that we can overturn cases on manifest weight of the evidence, which is standard of review, but it doesn't tell us what that means. So I went to Judge Painter's appellate practice book. I went through it, it's this thick. I went through the table of contents. Surely there was a definition for standard of review. There wasn't. So I went to the dictionary. And guess what? It's not there. It's not there in this latest edition of Blacks, or the latest edition that I could afford. So I had to come up with my own definition. So this is just one way to think about this. One way to think about what a standard of review is to look at what the purpose of the courts are, right? So we have 3 levels of courts: the trial court, appellate court, Supreme Court. What am I on? Thanks. Trial court serves to do what? Resolve disputes, right? They can't handle it themselves. They go to the trial court, file a complaint, answer. We heard all about that. How to get those dismissed in the last half hour. But they serve the problem is you have 2 kinds of cases, civil and criminal. And so maybe we're going to have some different standards of review for those kind of cases. The Supreme Court serves to do what? Someone please help me. They make the law. Okay. What? Maybe I should ask this question. What does the Ohio Supreme Court have to do? They actually have in the Constitution and statutes.
Okay, they have to resolve cases in which they have original jurisdiction.
Thank you. That's exactly what I was going to say, David. You actually paid attention back in law school. So they have to do certain types of cases, but for the rest of the time they're there, the other 11 and a half months that they are sitting, what do? Whatever they decide to do, right? So, and we heard about this in the manual earlier, didn't we? They decided that the Supreme Court gets a capital C, but the trial court doesn't. Yeah, so they get to do whatever they want to do. Now there's an appellate, and so we know there's 3 levels: middle level, or actually the most important level, because this is where all the appellate work gets done. Appellate court serves to do what? I'm not going to ask you because I'm going to run out of time. Serves to review a trial court's resolution of dispute. That's simple. That's what we're there for. The assignment of error. They did this wrong. We're going to tell you if they did it wrong or not. Important about some of the limits on the appellate court: it has to be a final order. So those 12 B's are kind of iffy. But what's the goal in resolving the dispute? When I'm thinking of, now remember, I'm saying this in the context of trying to define what a standard of review is. So if we think about the goal is to ensure that the trial court used the correct law and procedure to resolve the dispute. If that's the primary goal of the appellate court in Ohio, then we can kind of understand what a standard of review is. Standard of review is applied to certain aspects of the trial court's resolution of the dispute. And it's dependent upon what the trial court decision is being reviewed. Okay, so if we're reviewing a verdict, we use a manifest weight standard. If we're reviewing the introduction or exclusion of evidence, we're using standard. Someone say it.
Well, that would be abuse of
Well,
discretion.
everyone knows that you're all lawyers and smart. Use of discretion. Thank you. So earlier we had a presentation where someone asked, how do we decide which standard of review to apply to which decision? I have no clue. But the federal courts actually kind of tell us, give us guidance. They say that there's 3 basic categories of decisions, and you review them on appeal with different standards. If you're talking about a question of law, we look at de novo. If we're talking about questions of fact, We review it for clear air. We never use that in Ohio. We never say that, but we have it in a couple of standards. And decisions on matters of discretion are reviewed for, to be redundant, abuse of discretion. We kind of follow those guidelines. We just never put them out there. So if the appellate court uses the standards of review and applies them to different aspects of the trial court's resolution of dispute, what do those standards of review do? And I think I'm getting to a circular definition, but we'll get there. Do they ensure uniformity in appellate decisions? I don't know. Okay, they kind of do. But see, she's cheating. Yes, I'm there. Do they make opinion writing easier, Judge?
Yeah.
It's ready. Second. So they actually serve a lot of purposes. But for this half hour, 20 minutes that I get to talk to you, I have one way of thinking about it. Standards of review determine the amount of deference an appellate court gives to the aspect of trial court's decision being challenged by the appellant. You know, when I thought about this, I was trying to come up with what is a standard of review. So I looked at its purpose. It determines the amount of deference. Now, I just used the word deference. So I know you're all smart, you're all lawyers, you all have fast minds. You're thinking to the last slide. Because that's the big dispute, manifest way of the evidence. So, don't jump ahead of me. Okay, anyone, how many standards of review are there in Ohio? I came up with an exact and precise and technical definition. How is it? Okay. But guess what? All of them fit a pattern. De novo review. What is it? Over again, right? And in the context of my definition, what does the de novo review do?
Without deference.
You're cheating. You can't look over. You can't look at me. Thank you. No deference given, right? Whatever the trial court did, we don't care. So, summary judgment. What do we do? How do we review?
They know.
But thank you, John. Exactly. That's why there's no definition of standard of reviews, because not only do we apply one, we apply another one. And what is, I mean, I don't even know anymore, but what's the standard of review, Judge Boyle, of an agency decision going to the trial court appeal to our appeal? But what happens when it gets to the Supreme Court? What do? I have no clue. I really don't. Anyway, de novo review. What about abuse of discretion review? Again, I came up with a highly, highly technical and precise, right? We're all lawyers, right? Any scientists in here? No? Any patent lawyers? Any engineers? Okay, so you guys know that this is as precise as we get. An abuse of discretion review is, there's a lot of deference given. Okay, that brings me back to the 12B6, the venue, 12B3.
Venue is B3.
I paid attention. 12B3, you asked, why is that reviewed abuse of discretion? I'm gonna answer that at the end of my abuse of discretion.
I look forward to it.
There is a reason, and I think I figured it out after reading a few hundred cases in preparation for this, to come up with these technical definitions. So, manifest weight. Come on, everyone knows. Everyone knows if we gave no deference and we gave a lot of deference, my technical definition. Right? So, the standard review will, they just exist on a continuum from no deference to a great amount of deference. Is
coming back in appellate briefs at us.
Thank they come in a separate section so we can ignore it. Given great amount of deference given, what happens if there is no deference given? Do we have that standard of review? No, yeah, no deference. What if we give complete deference? Is that a standard of review that we have? No, because then that wouldn't be reviewable. Except, there's always exceptions. Anyway, so prior to 20, so now that I kind of put you in the mind frame to think about what a standard of review actually is, let's talk about abuse of discretion. Prior to 2021, the common definition, who wrote that, who read it, who knows it by heart? Everyone? An abuse of discretion is more than the error of law or judgment. I highlighted that part. We know what it's unreasonable, arbitrary, unconscionable. I don't know what those mean, because if it's not reasoned, it's no good. If it's arbitrary, it's a dark. If it's unconscionable, no one could ever do it anyway, right? But that doesn't help. I mean, how is something that the trial court admits evidence and says A, B, C, and D, that's why I'm admitting it? It's reasons. So I don't understand this that much, but we're going to talk about more than an error of law or judgment. Where'd that come from? There's one thing to note here, 1940 syllabus law. Does everyone miss syllabus law? I sure do. They talk about the meaning of the term abuse of discretion in relation to the granting of a motion for new trial. And they said it connotes more than error of law or judgment. Where did they get that from? No one knew, because no one ever read a case from 1940 in this room, probably. I don't see anyone old enough to do so. But in 2010, Second Appellate District Judge Fang said, wait a minute. This whole Steiner, quoting Blakemore, said, called that definition an offensive formulation in State versus Bowles in 2010. And they said, oh yeah, he actually went and read the 1940 case Steiner and said, oh, you cited the second edition of Black's Law, which in the 10 sub definitions actually had an abuse of discretion could be more than an error of law. But he then pulls out the 11th edition, finds out it doesn't work. And he says, maybe that definition came when they were trying to make a point. When a curative law is involved in appellate review, the mere fact of reviewing court would decide the issue differently is enough to find error. But in contrast, the issue on review has been confined to a discretion of the trial court. The mere fact that the reviewing court would have reached a different result is not enough to find error. So let's go back to your venue. If venue is proper in 88 counties in Ohio, if the person lives in Ohio, right? The judge gets a motion for change of venue. Is the judge mandated to do anything? Is he mandated to move it?
Yeah.
Is she mandated to keep it?
Not on an abuse of discretion review, no.
No. In the law, you said it's a venue. And I know that there's like two standards that are kind of there, but they're amorphous. And it's hard to really prove them. But the judge can keep it or not.
Yes.
That's why it's reviewed for an abuse of discretion, because either resolution of that dispute or that aspect of the dispute is correct. It's not mandated to do anything. That's why I think we apply that abuse of discretion to certain things. That's what, and I couldn't find someone saying that because no one wrote a definition of standard in the case law. But that's what I think is happening with abuse of discretion. But anyway, after 2010, how long did it take for Judge Fay to be listened to? Anyone know?
80 years?
11 years. The Supreme Court took note in 2021 in Johnson versus Abdullah. They said, and they acknowledged, hey, we said this. We actually said that it implies the attitude is more than the error of law. Judgment is the standard. And you know what? Some judge down in the second district said this is offensive. And then they went on and looked at Black's Law from the second edition to the 12th, I think wrong, or whichever. And then they did something which they're only allowed to do. They said, oh yeah, Steiner, we gotta put that in a box and say, yeah, that was about a motion for new trial. That really wasn't what we were talking about. And they went through and explained that not a trial court, notice a small c, not an appellate court, notice the small c, but not even the Supreme Court. They didn't write the manual, it just came out after this. They used a small c, has the authority to commit an error of law. So that was in 2021. What was going on before when we were all practicing law, which I'm going to go back to Blakemore to Johnson, quote, more than error of law. I found 2,500 cases citing to it as being more than error of law up until Johnson. Anyone have a guess as to how many cases cite that after Johnson? Only 116. Congratulations, judges. And more than a significant amount cited it to say this is not what we're talking about. So that's what an abuse of discretion is. That whole concept of making the error of law. Anthony, does that end it? Judge makes an error of law and it's reversed, period.
Not if it doesn't matter.
So you're telling me that there's a standard review of abuse of discretion? Could it be harmless error? Oh my gosh. Manifest weight of the evidence. Sorry, guys, I'm having too much fun with you. Manifest weight of the evidence. We have civil cases, we have criminal cases. Are there two different standards? Anyone? Civil lawyer? Criminal lawyer? Criminal lawyer up
Sufficiency
there.
of the evidence?
Huh?
Sufficiency of the evidence?
There's a sufficiency standard, but I'm talking about manifest weight. Appellant asks says manifest, this verdict is guilty versus guilty, manifest weight of the evidence.
Standard's the same between the two cases.
There you
It's
are.
supposed to be.
It's supposed to be, correct. It's supposed to be easily, versus Volkman, 2012, gave 3 reasons, it's the same. What's line, Easley? Prior to 2012, there was a civil standard used. Civil standard would confuse the sufficiency standard of review in a civil case, which gives great deference to the trier of fact. See this, where am I? Now I'm trying to get through this. Okay, manifest weight, there's one standard, it comes from State versus Tompkins. Okay. Okay, I want to talk about Seasons versus Cole, which was a statement about the civil standard before it was merged. I think it's unfortunately. The rationale in the Supreme Court in 1984 said in the civil standard, we're going to give some deference. We're going to give deference to a trial prior effects decision. In other words, it's kind of circular. They came up with this verdict, so when we're reviewing it, we're going to give deference about that verdict. But then Easley talked about why we only have one standard. And so what is manifest weight standard now that we have one after Easley? It says that, and State versus Tompkins in 1997 said that Court of Appeals may determine that a judgment of a trial court is sustained by sufficient evidence, but reverse as against manifest weight. So we know we can do that, and we know it takes 3 judges because that's in the Constitution. To do that, it concerns, and this is what Tompkins first said, that decision on manifest weight is the inclination of the greater amount of credible evidence offered in the trial to support one side of an issue rather than the other. It indicates that the jury that the party having the burden of proof will be entitled to their verdict if, on weighing the evidence, they find the greater amount of credible evidence sustains the issue to which is to be established for them. And this is what I like, because we're not scientists. Weight is not a question of mathematics, but depends on the effect in inducing belief. So if something is against the manifest weight, it means it didn't convince you. It also, Tompkins also went on to say, when a court of appeals reverses a judgment of a trial court, that it's against the manifest weight of the evidence. And we've all read this, the appellate court sits as a 13th juror, disagree with the finder's resolution of conflicting testimony. I want to go back, pretend we're all Supreme Court justices, and look at Steiner, that they put it in a box. I want to think about this as when we use this 13th juror analogy, that we remember that Tompkins said, this is when we're looking at conflicting evidence, not when we're looking at the entire case. I think that's where we're at, and then we have the complete standard, which gets to what it's about, says, whether in resolving a conflict in the evidence, the jury clearly lost its way and created such a manifest miscarriage of justice that the conviction must be reversed and a retrial ordered. And that power should not be used except in the exceptional case in which the evidence weighs heavily against the conviction. So we know that what we're doing here with manifest weight standard, in general, we're giving that entire case and that verdict and what supported it some deference. We're giving it a lot of deference because it has to be patently and completely wrong to be reversed under the Tompkins standard. So it's clear, right? Everyone understands that. Not really, because in RZC, the Ohio Supreme Court in 2023 last year addressed standard review to review a juvenile court's award of permanent custody. Okay, and this is where that old civil standard was coming up into play. And in ZC, they said, knowing that there was one review, they repeated the Tompkins overall manifest miscarriage of justice language, but then talked about giving deference to the finder of fact. And that was in 2023, after 2021, after 2011, Easley saying there's one. Tompkins doesn't talk about that deference, but we still have that appear in RZC. Now, that deference was used in a civil case to determine whether the case was sufficient, and it was going to be found to be sufficient if there was some kind of credible evidence going to every aspect. Civil or criminal has a slightly different sufficiency. There's only one manifest weight of the evidence standard to be used, but does that? I think the real issue coming forth because of RZC and because of Tompkins and because of Easley saying we only have one. Is there any deference to the finder of fact or to the verdict in a manifest weight review? And I'm ending now and giving these guys this, but if you really want to know the issue,
I'm answering a question.
I'm not answering a question. For once, I get to appear before all these appellate judges and not be an advocate. So take a look at State versus Riello. It came out last week or the week before, and it's 3307. It's not, and the 8th district should be in parentheses. I guess I didn't read the manual. So no, thank you.
This is why you don't split your time in oral argument. It never works. So our second half is on sealing and expunging because, as you know, the laws have changed a lot. What is the difference? What is the current status of the law? So we brought in two experts on that topic as well. We have Anthony Miranda, who's been an assistant county prosecutor for over a decade, dealing with appellate, post-conviction and expungement issues. And we also have Tom Lampin. Also, he's an assistant county public defender's office. Also deals with appellate, post-conviction, expungement issues. And side note, has been part of a team that has actually argued before the United States Supreme Court and won. So with that, I'm gonna just let you kick off, because it's coming to your time. Thank you, guys.
Yeah, let's see if we can get this done in 30 seconds a slide. So, yeah, just right off the bat, what is sealing and expunging? Generally speaking, they're both ways to sort of get rid of a criminal record, right? They work a little differently on the back end. They go a little bit further or not as far. But the general idea is, you want to restore someone's legal rights, the right to own a gun, things like that. And you want to repair their reputation, making them amenable to employment, housing, things like that. We'll get into some of the differences on the back end in terms of what they do, but they sort of work the same way, same statute that creates them. It's the same basic process you go through. So the threshold requirements, if you're going to get a record sealed or expunged, first thing you got to look at is whether the underlying offense qualifies. And we'll dig through that, but your crimes of violence, higher degree felonies, not going to be eligible. Step two, you got to make sure that the case you're working with has been finally discharged, right? So if they're still on probation, you're not eligible yet. If you haven't paid your restitution, you're not eligible yet. Court costs are a little different. They can still get your application denied ultimately, but it's not an eligibility threshold. Just a small distinction to be aware of. You can't have any other cases active separate from the one you're getting sealed or expunged. And there's waiting periods for different degrees of offenses. You can seal a misdemeanor pretty quickly, versus a felony, you're waiting typically a couple of years.
So we wanted to start briefly with how much the law has changed. So from 1975 to 2012, Ohio had what was called the first offender law. So what that meant is that you could only seal a conviction if it was your first offense. If you had a second or a third offense, any other misdemeanor or felony offense, you could not obtain relief. And so we've got an example of that in 1975. Somebody was convicted in 1966 of embezzlement. 8 years later, they moved to seal that conviction, but they're not qualified because they have a prior assault and battery conviction. So that's the law for more than 30 years. It's a very restrictive eligibility criteria. In 2012, the first offender concept is eliminated and the General Assembly adopts an eligible offender definition. And the definition is basically the person has not more than one felony, not more than 2 misdemeanors, or not more than 1 felony and 1 misdemeanor. So a little bit of wiggle room. You can have a second conviction, but still not a lot of eligibility. The big change came in 2018 when the General Assembly widened it out to include up to 5 felonies of the 5th or 4th degree. And so it was that change where we started to see people with drug offenses and theft offenses where you're more likely to see multiple convictions obtaining relief.
All right, so where we're at now, 2023, the legislature made another really big expansion on who's eligible and what is eligible for expungement. And the way things work now, the focus is generally on the underlying convictions themselves when you're looking at eligibility, for the most part. First and second degree felonies, never going to be expungible, at least under the current law. Any violent felony is not expungible. The violent misdemeanor can be expungible. And one important thing to note here, sexually oriented offenses now can be expunged as long as you're not a registered sex offender anymore. While that registration requirement's in place, you can't get your record sealed. And separately, any offense against someone under the age of 13 is not eligible. That's not just sexually oriented offenses. That's if you knock over a lemonade stand, you can't get that expunged either. The main takeaway from these changes, it doesn't feel like if 2023 was just a year ago, right? So as of just as recently as last year, there's a large number of now sealable or expungible cases that weren't eligible even just a year ago. If you have any number of fourth or fifth degree felonies, violent misdemeanors, low-level sex offenses, not too long ago, those weren't something you could seal or expunge. Some numbers Anthony gave me just to kind of give you a sense of the scope here. Since eligibility has been expanded, we're seeing around 3,000 to 4,500 expungement applications per year. Anthony's also quoted me that there's about 10,000 people getting indicted every year. So, kind of looking at these trends, looks like these numbers are pretty much going to stay where they're at. About a third to a quarter, a half or so of what's being indicted in Cuyahoga County eventually becomes sealable or expungible. So we're going to keep seeing these numbers. And that's a lot, right? There's a lot of these to deal with. I know Anthony's office is kind of managing drinking from a fire hose here. Now you might have noticed there was a little bit of a gap when I was talking about what's eligible and what's not for third degree felonies. This is where the statute works in kind of a strange way, a little bit more like it used to work prior to 2012, where you look at the overall criminal history. That's the statutory language there, but here's kind of mechanically how it works. If you just have one third degree felony, you can get that sealed as long as you don't have more than 2 other felonies. So 1 F3, 3 total felonies, you're in good shape. If you have 2 third degree felonies, those can be expunged as long as that's it. You don't have any other felonies and you don't have more than 2 misdemeanors. So a little bit less permissive there. And if you have 3 third degree felonies, you're going to have them forever. Those can't be sealed or expunged. Mechanically, it works a little differently depending on how those convictions are arranged. And the thing to keep in mind here, you can't half seal a case, right? You can't half expunge something. You can't half destroy a file. So if you have eligible and ineligible convictions in the same case, that's not eligible. But if they're in separate cases, you could at least seal, for example, some 5th degree felonies, even if those are preventing you from sealing a 3rd degree felony.
Question?
Yeah.
So what you just said, does that mean like if someone gets the felony court on the OVI misdemeanor, but then they find other stuff in the car, guns, drugs, whatever you want to name it, those won't be eligible because the misdemeanor OVI is not eligible to be sealed or expunged, so then the rest of them can't be?
If they're all in the same indictment and it's a part of one conviction, then yeah. And as another note, you can't seal your misdemeanors to get under that threshold and then come back and seal your felony 3s because a sealed conviction still can be accessed by a court. Yep.
On your OVI cases, though, make sure you take a look at the rule about sealing multiple records, because if you obtain a resolution on the OVI that is not itself an OVI, or I believe a physical control, you will be able to seal that record. So if you can get it down to something that's not an OVI, you may be able to seal the felony record that came out of it or other misdemeanors that came out. And it's in that rule about sealing records of multiple cases that you see that bit about OVI specific.
Great point.
So we're just gonna move a little quickly through some of these. Obviously, the details and sites are all in the slides. Final discharge, that means you gotta be done with your prison sentence, done with your supervision, pay your fine, pay your restitution. You don't have to pay court costs to achieve final discharge. If you have any pending criminal proceedings, that's gonna disqualify you. So if you have a pending indictment or complaint somewhere, you gotta resolve that first. If you have arguably an active arrest warrant, that's gonna disqualify you until you resolve that. There's currently a conflict among the districts about whether or not being on probation in a separate case would disqualify you. I don't know that the 8th district has answered that. So that's something to be aware of. There are specific waiting periods for you to wait after you have achieved final discharge. So depending on the level of the offense, for example, if you're convicted of a sexually oriented offense, you have to wait 5 years from final discharge, and then to seek to expunge, would have to wait another 10 years to achieve eligibility for that. And so that's just a chart that Tom has.
So real quickly, just to get through the differences between sealing and expunging, probably a nice top level way to think about it is sealing a record kind of controls access to it. It removes the public's ability to find it and limits who else is eligible to look at it. An expunged record, the file is physically destroyed and can only be used in very, very specific circumstances. With sealing, you can probably imagine generally the occupational screening that can access that, healthcare, education, that type of thing. And a sealed conviction can come back if you're applying to seal another conviction. That's why you can't kind of chain your way up to sealing a F3. Expungement, little different. Like I said, the file is physically destroyed, except in very, very narrow circumstances, really outside of applications to become a law enforcement officer, or if for whatever reason you got convicted of something that disqualifies you from holding public office. Those are some of the only circumstances where a expunged conviction can be used. They can be introduced in court, but not for purposes of sentencing. A sealed conviction can be used for purposes of sentencing as an enhancement. Expunged convictions can't.
So we just lay out the process, at least in terms of how it works in our common police court here. Generally, you file the application. Prosecutor now has a statutory obligation to notify victims, which did not previously exist. And so that's happening at the beginning. The court has to order the probation department to prepare a report. The prosecutor then files a response once the report is obtained. Typically, if the prosecutor and the victim are not opposing, typically these are granted without a hearing. If there's some kind of opposition, then a hearing is scheduled. This is just an example of a report, how to read it, what to look for the relevant parts, the relevant conviction, whether there's financial obligations outstanding, whether there's pending criminal proceedings.
So those EIRs are really important. That's how the state's response gets formulated. It's the main thing the court looks at. Just from having worked on a lot of these are some things that can come up. They're common enough, you'll probably run into them eventually, but they're weird enough to take up time to resolve. The main, probably the most important one, not a lot of times, because the court changed how its payment processing worked in 2007, you can run into a situation where your client paid their restitution, paid their probation fees, their fines, but it doesn't show up in the court's accounting system now. I know when it happens, but I don't know why it happens. And you can get that resolved. You can go to the finance department, get an old statement for the pre-2007 accounting system. But that's gonna flag on the investigation report and make it look like they're not eligible when they are. I've run into instances where someone else with the same name has charges and those show up on an EIR. Anyone who's done criminal defense has probably heard their client say, no, I swear that wasn't me. But sometimes that is actually true. And it's pretty easy to resolve ultimately if you dig into it a little bit. Birth dates, addresses won't match up. And lastly, convictions from different jurisdictions, they can show as unresolved or as still pending when they're not. And generally you want to call a out-of-state clerk's office and ask them, because you never know. Sometimes they'll say, oh, we dismiss everything if it's been inactive for 5 years, and that's not reflected on the docket, but your client doesn't have an active case. And very briefly, there's some legal issues surrounding the need for a hearing as just bottom line practical matter. If the court is going to deny the application, they pretty much have to hold a hearing or they risk getting reversed. If they're going to grant it, I know the state's been waiving their right to a hearing. So if you're going to get it granted, you might not have to have a hearing.
So there's more material in there, but maybe we'll end there and ask if there's any questions.
Yeah, you bring it on.
The trial court converts restitution to a civil judgment. Restitution paid. Is it eligible for expungement?
You want to repeat the question so everyone can hear?
If the trial court converts a restitution order to a civil judgment, does the offender become eligible to expunge?
That's a
question? I would think so if it's no longer part of the sentence, because the issue with restitution is you need final discharge. If that conversion gets it out of part of the sentence, then I would think so, but.
So there's a case pending in the Supreme Court, TWC, which is 2024-0265, where trial court basically waived restitution and the 10th district upheld it as kind of being civil in nature, and so the Supreme Court has that in front of it now.
To say I had that exact issue in our problem. The court didn't think that they were ineligible, but the problem we ran into is the trial court judge didn't like it.
That's always a problem.
One thing I do want to toss out here real quick is in the materials, there's a template letter that you can give to your clients if down the line, they get their sealing, they get their expungement, but commercial background checks still show the conviction. There's some federal law that governs background checks, and this kind of walks through how that would work, but that's just available for you down the line.
Well, Matt makes a good point. Say you meet all of the qualifications, but the trial court's inclined to deny the application. And then if so, what standard would apply on review?
It seems to me that you all have written repeatedly that it's an act of grace and that it's an abuse of discretion standard.
That's right.
Yeah.
Okay, we'll be here for a minute if anyone has other burning questions. Go ahead and have lunch. So, okay, free lunch out in the hallway. Grab your lunch for 15 minutes and we'll get started at 12:15.